Next up, it is my pleasure to introduce to you Deborah Stevenson, attorney at law. Mrs. Stevenson is a 1999 juror doctor graduate from Quinnipiac University School of Law. While there, she was awarded with the following honors: Excellence in Clinical Work Award, the McGarrity Farrell Scholarship Award, given for work performed in conjunction with the state legislature to support parental rights. She was the moot court invitee and is a Who's Who American Law Students, Volume 17. From 1999 to the present, she has been a tireless advocate for families in the courts and outside of them. She specializes in juvenile law and educational law and has worked for special education and mentally disabled advocacy law practiced before state and local government and private agencies. Her practice is extended to civil trial, appellate practice in state and federal courts, and she has worked tirelessly for Connecticut families. In her free time, she donates many hours to community grassroots groups. She is currently the advisor to the following: Grassroots Parents for Education, Connecticut Against Common Core, Connecticut Youth and Government Program, and more specifically, the Thomaston Delegation, and is the founder and executive director of National Home Education Legal Defense, among others. Ladies and gentlemen, Attorney Deborah Stevenson, thank you.
Thank you very much. I actually am going to need a little handheld mic. Thank you all for coming. I really appreciate it. What I want to do today, now you've had that wonderful presentation on the educational basis, I want to tell you all about what you can do about it, where your parental rights come from, and how that is reflected in the law, and how our educational laws are developed, and a little bit about relating to Common Core, a little bit about the Common Core laws, and how you can affect them. So in order to do that, what I need to do is go back in history, in time, to explain where your rights come from, because it's not taught anymore. Most of you may know, but just to review, this is what I want to do. It begins with the Declaration of Independence, because before the Declaration of Independence, all of the countries in the world had a king or some leader who granted you your rights. The Declaration of Independence was very different. Our country was very different. It is very, very unique. We declared that we were independent from England, where we had a king who gave you your rights. We were tired of that, and so this country was founded on individual rights, and that we, the people, already have rights when we're born. The Declaration said, "We hold these truths to be self-evident. All men are created equal, that they are endowed by their Creator with certain unalienable rights." In other words, nobody gives us our rights but our Creator. We have them when we're born, and they cannot be taken away. That's crucial to understanding how you can affect anything today or in the future. You know what? I'm going to fall on that. After we declared our independence and we fought the war and we won the war, then we had to decide, how are we going to govern ourselves? And then we had the debate over the Constitution. The Constitution was formed, the Federal Constitution was formed, because all the states wanted to join together to protect our rights. And how do we do that? We need one overriding entity in order to protect our freedom, the freedom of the states and of the people. So we decided to write a constitution to join us like that. Now, the founders knew about how people are and that power corrupts and absolute power corrupts absolutely. And so they decided there has to be a way to break things up, checks and balances, in order to try to protect our freedom. So the U.S. Constitution was made from the people. We, the people who have all of the rights, decided to give some of the rights to a federal government for the protection of all the rest of our rights. So what we did was we said, okay, we're going to have a little bit of rights given to the legislative branch, a little bit of rights given to the judicial branch, and a little bit of rights given to the president. I've got to get that off. At any rate, so we, the people, gave a little bit of our rights to the federal government. Now, after we did that and we wrote the Constitution, then we gave it to the states to decide whether they were going to ratify it. Well, the states said, the states were already running themselves. People were running themselves in the states. States had constitutions of their own. And so the states were a little bit suspicious of the power of the federal government. So they had a debate. They had a lengthy debate. It took 2 years for the Constitution to be ratified. And what the people in the states were talking about is, well, we don't want this federal government to take over the state power. How are we going to do that? And they were very suspicious of that. And so the founders wrote letters, but they didn't necessarily want their names to be included in the letters, so they wrote under pseudonyms in the newspapers of the time, and it took 2 years. And they debated these issues. Which is more powerful, the federal government or the state? How are we going to do that? It was all explained, and we compiled all those letters to the newspapers in a document which we now call the Federalist Papers and the Anti-Federalist Papers. And so everything that I'm going to tell you basically is in those documents. And if you want to know about them, and your children should know about them, you need to research them and read them because it's very informative. So what happened was, everybody knows about the Preamble to the Constitution, but do you know about the Preamble to the Bill of Rights? How many have read that? Okay, that's something also you need to look at. When you find your little pocket constitutions, some of them have the Preamble to the Bill of Rights, some don't. Get the ones that have the Preamble to the Bill of Rights. Because what happened, as I said, they had this 2-year debate, and the state said, okay, only if we are assured the federal government is not going to take away the state's power and the power of the people, will we ratify this Constitution. And so it needed to be amended. So they said, here's 10 amendments. If you adopt 10 amendments to this Constitution, Congress, then we can ratify it. And so they made sure, and they put in the Preamble to the Bill of Rights. And this is what the Preamble says. The conventions of the number of states, having at the time of their adopting the Constitution, expressed a desire in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added to the Constitution. That was the purpose of the Bill of Rights. If you can't understand federal government, what powers we gave to you in the Constitution itself, then we're going to make sure that you know by adding these 10 amendments. We're going to make sure you don't misconstrue or abuse the powers that we're granting to you. Two of the Bill of Rights, rather, the 9th and 10th Amendment, were key to that. The 9th Amendment talks about the powers, the rights, rather, and the 10th Amendment talks about the powers given to the federal government. And these are key to your understanding of what your rights are today. Because it said, if you can't understand the powers and rights we gave you in the Constitution, the 9th Amendment says the enumeration in the Constitution of certain rights that we gave you shall not be construed to deny or disparage others retained by the people. We have the rights. You don't. We only gave you some of them. So if you can't read that, the ones we enumerated in the Constitution, know this. We have all the rest of the rights. 10th Amendment talks about powers. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. In other words, we gave you limited powers and limited rights. The rest belong to the states and the people. We are the ones that created the government. The government does not have all of the power and is giving us some. We have all of the power and we gave them only some. That's crucial to your understanding of where your rights, parental or otherwise, have come from. Now, if you look in the Constitution, federal Constitution, and you look at the enumerated powers granted, that we granted to it, you will not find the word education. We did not grant to the federal government the power of education. We did not grant to the federal government parental rights. Those are powers and rights that are retained by the states and the people. But you say, well, we have all sorts of federal education laws. Where did they come from? We have No Child Left Behind. We have Race to the Top. How that came about was through the spending and taxing clauses of the Constitution, because we did give the federal government the right to tax and to spend. However, we only gave them the right to tax and spend for specifically enumerated powers that we granted to them. That last part is largely forgotten today. They're only supposed to tax and spend for the specific powers we granted them, education not being one. Nonetheless, we'll skip over that part that they've ignored. And what happens is the federal government will say, states, we'll give you X number of dollars if you, states, adopt a law that looks like this. And that's how No Child Left Behind and all the other education statutes have come into being, because the state said, okay, sure, we'll take X number of millions of dollars, and then we'll adopt a law and make our states comply with the agreement we have made with you, with the federal government. Sorry about that. Technical difficulties. I'm not technically inclined here. At any rate, my point being, that's how Common Core and all of the rest. Common Core, as you'll hear from probably other speakers, came into being because we made an agreement. No Child Left Behind is what we originally agreed to. And then there was, I believe, a waiver, and we made another agreement. And so, okay, we'll do this Common Core thing. Not going to go into exactly that at the moment. But the point being, this is how it came about. Now, Connecticut does have a constitution as well. And what does our Connecticut Constitution say? Does it say anything about parental rights? Not really, but it does talk about education. We have a preamble to our Constitution, to the Connecticut Constitution, and it says, the people of Connecticut acknowledge with gratitude the good providence of God in having permitted them to enjoy a free government, do in order more effectively to define, secure, and perpetuate the liberties, rights, and privileges which they have derived from their ancestors, their creators, we hereby, after careful consideration and revision, ordain and establish the following constitution and form of civil government. In other words, in Connecticut, developing our Connecticut Constitution, we the people also recognize that our rights come from our Creator, and we are only granting to the state certain powers and rights that we specifically enumerate in our Connecticut Constitution. And that is the purpose of the Constitution, to limit our state government. Education in our Connecticut Constitution. Article 1st talks about the Declaration of Rights. And it says, again, that all political power is inherent in the people. Just to make sure that we really know, we're setting out in the Constitution, we have the power, not the government. Article 8 talks about education. Section 1 says, there shall always be free public elementary and secondary schools in the state. The General Assembly shall implement this principle by appropriate legislation. That is what we talk about in our Connecticut Constitution. We, the people, gave the Connecticut General Assembly the right to make appropriate laws because we have established in our Constitution the fact that there shall always be free public elementary and secondary schools in this state. So the General Assembly now can make laws to implement that portion of the Constitution. Section 4 of Article 8 also says the fund that we talked about, there shall be a fund called the school fund, and it shall remain a perpetual fund, the interest of which shall be inviolably appropriated to the support and encouragement of the public schools throughout the state, and for the equal benefit of all the people thereof. The value and amount of said fund shall be ascertained in such manner as the General Assembly may prescribe, published, and recorded in the Comptroller's office, and no law shall ever be made authorizing such fund to be diverted to any other use than the encouragement and support of public schools among the several school societies as justice and equity shall require. That is what is in the Connecticut Constitution. There shall always be free public elementary and secondary schools, and there shall be a fund established to support those free public and elementary schools. The General Assembly has the authority to appropriately legislate to implement those two sections of the Connecticut Constitution. Now, Connecticut Constitution did not delegate any of its authority to the federal government. Neither did the U.S. Constitution. We, the people, have that authority. We have, in the General Assembly, established certain things to implement what is in our Connecticut Constitution. We have established, General Assembly has established a State Board of Education. The State Board of Education's powers are defined in Connecticut General Statute 10-4. Now, I would suggest that all of you go look up some of these statutes at least so that you know exactly what they say, because a lot of times you will then know more than the government officials know, because half the time they haven't read them. So it's easy to find on the state's website, ct.gov, and then you click on the legislative branch and then you look up the statutes. Connecticut General Statute 10-4 says, the State Board of Education has the authority to prepare such courses of study and publish such curriculum guides as it determines necessary to assist school districts to carry out the duties prescribed by law. Now, that does not say the State Board of Education shall develop curriculum and compel local districts to accept it. It does not say that. It says State Board of Education has the authority to come up with things, to guide, and to assist your local school district. That's very important for you to know, because I guarantee you most of the Board of Education members in your local towns don't know that. They think that they are compelled to do what the State Board of Education says, and that's just not true. It does not grant the authority to the State Board of Education to compel local boards to adopt any particular curriculum. The State Board may do so only when the local board or local school is deemed to be a low-achieving school pursuant to an act that was adopted in 2010. There is a certain portion of the statute the General Assembly adopted that said, okay, we're tired of having low-performing schools, and so we're going to grant to the state the power to come in and take over those low-performing schools and then compel them to do what we want. Only in that specific situation can the state compel a local board to do something, and there's certain criteria for that before the state can come in. Generally speaking, for most of your local boards, State Board of Education cannot compel the local board to adopt any curriculum.
Can I ask a quick question, Deb?
Yep.
Doesn't the surrendering of the authority over these standards to the two nonprofit corporations constitute a violation of that statute?
Well, there are many violations that I can get into an answer at the end of the presentation. I just want to make sure you know the foundation first for where your rights are, for what the actual General Assembly has adopted, and then we can go from there about what to do about any of the things that either have been adopted in violation of the Constitution or just are not what you want to see happen in your local district, because the local board does have the authority. I'm going to get into that right now. Connecticut General Statute 10-20 defines the powers of the local Board of Education. There's one subsection of that, subsection E, that says, and this is the crucial one for you, each local and regional Board of Education shall establish a school district curriculum committee. The committee shall recommend, develop, review, and approve all curriculum for the local or regional school district. That is where your local Board of Education derives its power from. That is not a suggestion. It is not a thought. It is a mandatory obligation on your local Board of Education to establish a curriculum committee and to adopt all curriculum, period. Does your local school board know that? Have they actually followed that? Have they established a school district curriculum committee, and has it voted on any particular curriculum? It's a question you need to ask before anything happens, but that's where the power comes from. If that gets changed by the General Assembly, then we will lose local control, but that's the local control that you have. There are other statutes that you should know about and be aware of for this continuing effort. Connecticut General Statute 10-157B requires each public high school and public institution of higher education to, quote, complete curricular alignment to enable the successful completion of high school mathematics and language arts curricula as described in Connecticut's Common Core state standards. Now, I want to explain what happened here. The General Assembly was not asked to, quote unquote, adopt a statute to adopt Common Core. Why? Well, Common Core curriculum or standards. Why? Because, gee, people might have gotten a little upset at that, I think. This is just my guess. But nonetheless, they were not asked to adopt a statute like that. That statute does not exist. The Connecticut General Assembly did not say, we hereby adopt Common Core state standards and curriculum, and everybody shall follow it. They didn't do that. They did adopt certain other pieces that help to make local boards think that they have to do something. Again, they did not change the fact that local boards shall adopt the curriculum. But listen to what it said. It said, you have to complete curricular alignment. What does that mean? What does alignment mean? Not defined. For what purpose? To enable the successful completion of high school math as described in Common Core. Well, if you align your curriculum by, say, adopting whether it's classical curriculum or some other curriculum, and your students are enabled to pass a Common Core state standards, well, that should be sufficient because it's not defined otherwise. It's not prohibited. So that is very open-ended, but it's a way to make you think, okay, well, we have to do Common Core. We have to adopt the standards. That's not what it says, but it makes you think that. You can make a credible argument about that. Okay? Connecticut General Statute Section 10-14N requires each student enrolled in certain grades to, quote, take a mastery examination in reading, writing, mathematics, and science. This goes to a question earlier. What is a mastery examination? Well, we've sort of known that for years, that if you teach something, you should master it, and that means you should know it. That's kind of general. It's not defined, again, in the statutes. But that's what the CMTs and the CAPT was all about, one would think, traditionally in the public school system. Now they are saying the SBAC, the Computer Adaptive Test, which changes and which has questions unrelated to the actual ability of a student to read and write in terms of behavioral questions and things like that, honesty and whatever, are on that. Is that a mastery examination? Could make a credible argument that it's not. However, your 10-14N requires each student to take a mastery examination. The mastery test shall be provided by and administered under the State Board of Education. So the State Board of Education provides, in this instance, does provide the mastery test and administers it under its supervision. However, there's no statute that addresses the issue of opting out of that test or any other standardized test. There is no statute that precludes a parent from opting out of that test or any other test either. Right now, that's an open-ended question. Nothing precludes you from opting out. And in fact, you'll hear, I'm sure, from other speakers that the State Board of Ed has admitted that. You can opt out. Gave you a hard time, but you can opt out. Excuse me. Now, where else do your parental rights come from? Well, we've already established it's not specifically in the Constitution. We already have them. The judiciary, the judicial branch, is not supposed to make law, either state or federal. The legislative branch is supposed to make law. However, The United States Supreme Court, in a case called Marbury versus Madison a long time ago, the late 1800s, decided, one judge, the justice, decided, well, you know what? We should have the power to interpret law, interpret what the Constitution means. And so they decided, yep, we have that power. Not granted in the Constitution, yet that's what they do, and that's what's continued from that time on. Well, we, the judiciary, can interpret what the Constitution means. I have, and will continue to argue that that's not constitutional. However, that's what is happening. And the United States Supreme Court has decided certain cases that are important to your parental rights if we're playing that game, if we're using that theory. And Meyer versus Nebraska, Pierce versus Society of Sisters, Wisconsin versus Yoder were some of the classic cases the United States Supreme Court decided that parents have a fundamental constitutionally protected right to the upbringing and education of your children. Now, that doesn't mean the state can't regulate it, according to the United States Supreme Court, but that's what those cases said. So you can use that theory, those cases, to argue that you have the fundamental constitutional protected right to the upbringing and education of your child. When parents bring their child to a public school, they don't relinquish all of their parental rights. They allow the school administrators to take the place of the parents temporarily for the purpose of providing the child with education. This power is commonly referred to as in loco parentis. It's a temporary, voluntary relinquishment of certain of your unalienable rights to the local public school for a specific purpose of educating your child for those specific hours. Period. You did not give up all of your parental rights when you enrolled your child in a public school. Parents can take back their authority, their unalienable right to the upbringing and education of the child from public school administrators at any time. Parents also have the statutory obligation to protect their child from harm. That comes from Connecticut General Statute 46B-129, among others. Parents are supposed to not neglect or abuse your children. You're supposed to protect them from harm. That's your statutory obligation. Well, parents may reassert their authority to protect their child from harm at any time they think their child is being harmed. Whether it's in the public school or out of the public school, you still have the obligation to protect your child from harm. If you think your child is being harmed by anyone in the public school or anything in the public school, you have the right and the obligation to protect your child. The bottom line is that we, the people, created our government. We gave some powers to the federal government, some powers to the state government, but we retained the rest for the states and ourselves for the purpose of protecting our freedom to do as we deem fit for ourselves and for our children. What powers we gave to any government, we gave to secure and protect our already existing unalienable rights given to us from our Creator. Our state legislature gave the power to develop and implement curriculum in our public schools to the local boards of education. That exists right now. It may go away, may be changed, because your General Assembly has the power to change it, because we gave them the power to make laws and to change laws. That one law, subsection E of 10-220, is crucial to retaining local control of your educational system. That needs to stay where it is if you want to retain local control. Local boards of education have the power to accept or reject any proposed curriculum, Common Core or otherwise. But ultimately, parents retain their unalienable right to the upbringing and education of their children and may choose what is best for them. Now, there were certain questions that were posed to me to try to answer that may be frequently asked questions. So I'm going to go through a little bit of that right now. I think maybe other speakers have a little more detail on them. But one of the questions I was asked to answer: what rights do parents have regarding data collection of medical records or any other records? This gets a little complicated. Again, we have rights. They didn't go away. But there are laws that were passed, and I have to emphasize that I see the Constitution as a filter, or a rule. This is our rule book. The Constitution, United States or Connecticut, is our rule book. You would not play a game of football without a rule book. When you play football, you play by the rules, and if you ignore the rules, you're still playing a game, but it's not football. Okay? So we have a Constitution, and people should be playing by that rule book. If we're not playing by the rule book, we're still here, but it's not the country that was developed. It's not the country that the rule book says it should be. So, what rights do we have regarding collection of data? Well, there are many federal and state laws regarding privacy of records that have been adopted. Doesn't mean that all of them are constitutional, but nonetheless, they're on the books until somebody does something about it or challenges it that it is not constitutional. Just one of those rules under 20 United States Code 1232, the Protection of Pupil Rights Act. Under that act, no student is required to submit to a survey, analysis, or evaluation that reveals information concerning, among other things, the political affiliations or religious beliefs of the student or the parents, the mental or psychological problems of the student or student's family, illegal, antisocial, self-incriminating, or demeaning behavior without the prior written consent of the parents. Sounds good, right? A little protection there. Well, there's an exception to that. The exception is, well, personal information from students can be collected to develop, evaluate, or provide educational products or services for students or educational institutions. So you have to have written parental consent, except if you want to develop some products or whatever, you don't need parental consent for that. So do you see, you can pass a law, it's constitutional, maybe it's not. But even in the law itself, even if it is constitutional, they can write in exceptions to that. It's crucial to know what the law actually says, whether it's a state law or a federal law, because those exceptions are important, and they may name it a great-sounding Pupil Protection Act, but what does it actually say? The exceptions are important. The language is important. Almost all of the laws, federal and state, in this area in particular, data collection, have exceptions. Under the exceptions to the Federal Education Rights and Privacy Act, FERPA, even personally identifiable data collected may be shared among the agencies, different agencies, without obtaining student or parental consent. If the person or agency has a legitimate educational interest or is designated as an authorized representative. In other words, you think your rights are protected under FERPA, but no, that can be shared too. The data collected by anything in the school system can be shared among agencies, and if the school happens to say, well, I designate you over there as my authorized representative, could be anybody, could be an organization, could be a company, then they can share the data with them. Again, an exception to protection of your rights. That was just passed recently. What is personally identifiable information? Because they say that's generally considered to be protected, right? Well, personally identifiable information is considered to be the name, address, and social security number of the child. It must be used, for example, however, for some software to function. So in order to get this software, the data collection, to function, you have to use personally identifiable information. Name, age, social security number. That has to be used to have the software function. Fact remains, however, that it is possible that the child's personally identifiable information, even though they say it's protected in some cases, may be obtained or tracked. How is that possible? Well, each child is given a state-assigned student identifier, a number. Instead of putting that name, address, and social security number, they give the student a number. And then they leave the personally identifiable information over here in the local district, but they share everything else, including the student's number. Well, how easy is that to trace the number back to the personally identifiable information? How easy it is for somebody to hack that? We don't know. But yet, again, you have to read all this stuff to actually get it and think about it. Because otherwise, personally identifiable information is not provided. We're protecting that. Really? How far are you protecting it? Another one, under Connecticut General Statute 10-10A, the state has established a statewide public school information system to collect data and, quote, facilitate compliance with state and federal reporting requirements. That's called the Preschool Through 20, or P20, Workforce Information Network Snapshot, P20 WIN Data Sharing System. The data will be shared with institutions of higher education, other state and federal agencies, such as the Department of Labor, the Office of Early Childhood, and UConn, as well as with, quote, any other organization pursuant to an authorized agreement, including those conducting research. Okay, so this is where your students' data is going. And Cheryl will give you a lot more details about this. I'm just trying to touch on the legalities of where your rights are and why you need to know. The agents currently participating in the P20 WIN data system, well, they've pledged to keep it private, to keep it secure. A pledge. But the data pledges simply state, for example, they will comply with all applicable federal and state statutes, including FERPA and HIPAA and, other things. Well, there are exceptions to those. So how good is their pledge? Okay, going on to another question that I was asked to answer. What right do we have to know what they plan to teach or share before they do it? In the public schools, Common Core, or whatever it is. Well, parents have the right to inspect and copy at any time during regular business hours any public document, including curriculum and materials, maintained by any local Board of Ed or school district administration. That comes under your FOI laws. It comes under other statutes for your parental rights to see your own child's educational records. But the curriculum and materials, yes, those are all public records, public documents that you can obtain. You can also demand local boards amend the curriculum or materials used at any point. Again, if a parent deems anything harmful to the child, parent has an obligation to protect the child from harm. So how do you know? You need to ask first. You need to go in. You need to actually be there and make those FOI requests. Another question. Could a group of parents file a class action suit regarding data collection having to do with parental control and parental privacy? Yes, anyone can file any action in a court and argue that their statutory or constitutional rights are violated, assuming they have an adequate basis and evidence in the violation. There may be many arguments to be made, either in court or the political arena, that the federal government has no constitutionally enumerated authority to compel collection of educational data, or the data being collected violates the fundamental rights of parents to the upbringing and education of the child. Now, however, when you file a lawsuit, class action or otherwise, keep in mind that's going to take probably a long time to go through the court system. It's going to cost a lot of money because not only do you have filing fees, but during the process of obtaining information, the discovery process, if you have depositions, you have to hire court reporters, you have to go through a long, lengthy process, and the first thing the opposing person does is file a motion to dismiss, and you have motion after motion to stop you every step of the way, and you have to have evidence to prove any violation. Not unheard of. You can do it, certainly, but you have to know going in what you're getting into. There may be other effective ways, politically or locally, that you can take in order to stop this. Again, you have 3 branches of government, not just one. That is a viable option. I would say the legislative branch is another viable option. And I truly believe that this next legislative session here in Connecticut is going to be crucial, absolutely crucial, to what happens. Because not only are we talking about Common Core, but we're talking about other educational issues, other issues affecting parental rights that will be coming to the forefront in this next session that are in the works being implemented. And if you look at them all, you can kind of see where it all fits together. We have just had last week the Sandy Hook Advisory Commission come out and talk about what it may propose for its recommendations having to do with school safety and education. I mean, nobody wanted to see Sandy Hook happen. Everybody wants to solve that problem, prevent it from happening again. But it matters how you go about it. And we saw in the very first aftermath of Sandy Hook how the legislature wanted to do something and took action. Well, they came out with a lengthy bill having to do with mental health, with gun safety, school safety, very lengthy bill. But they didn't have a public hearing on it. They ignored the rules of the legislature in adopting it. They were in a hurry because it was politically advantageous to get something done at that point. Part of that initial bill was to establish DCF as a lead agency to come up with how are we going to help all of the children in the state? How are we going to screen all of the children in the state to see if they have mental illness, so we can prevent Sandy Hook from happening again? So DCF has just come up with its final recommendation October 1st. That's a 62-page document going to implement all sorts of things, including mental health screening of all children, and a lot more. You need to know about that piece. You need to read that piece as well. That the original bill that established that was Public Act 13-178. So you can Google that and come up with the final recommendations that were adopted. Now, nothing can happen. These are recommendations. They have to go to the legislature to be adopted, proposed as a bill, and then adopted. So you can work politically on that as well to try to get them to be adopted or not, however you stand on the issue. But they affect your parental rights. They affect children, mental health screening of children. All the data that's collected from the mental health screening probably will be uploaded into this system and follow them through their workforce, through their lifetime. These are things that you need to think about, not just Common Core and that. Now the Sandy Hook Commission has not come up with its final recommendations yet, although they talked about them. One of the things they talked about was the possibility of, all homeschooled students shall have an IEP, an individual education plan. And if the child does not show adequate progress in the individual education plan, then that child cannot homeschool any longer. That was one of their draft proposals. Really, on what basis, on what facts do you have? Why? Well, they think that Adam Lanza was homeschooled. However, in 2013, the Office of State's Attorney came out with a report saying that Adam Lanza graduated from Newtown High School. He was identified as a special needs student and had an IEP. Well, although he didn't go to the school for part of the time. That must mean that he was homeschooled. Well, no, homeschooling is different from enrollment in a public school and through the IEP receiving tutoring at home. That's called homebound instruction. That's called a specific IEP. The student is still enrolled. That has nothing to do with homeschooling. Yet the Sandy Hook Commission is proposing this for all homeschoolers. Now, it hasn't come out with its final recommendation yet. Maybe it will be in there, maybe it won't. My point being, all these pieces are all in there. And all of them are set up to be proposed in the next legislative session. So which you always have to determine what your strategy is. Do you go to a lawsuit to take action? Do you go to the legislature to take action? But even if the legislature takes action, guess what? The governor has to sign any bill. So there's a third branch you can have an effect on. So that's the beauty of our system. It's broken up. You have opportunities every which way. You need to know your rights. You need to know what the facts are. And you need to determine your opinion based on the facts and then determine what appropriate action to take on each different issue. So crucial is going to be who's in the legislature, who's in the governor's office, and who are they going to nominate to be in the judicial branch. That's always the case, but it's very crucial right now because all of these recommendations are sitting there alongside this, and ready to be proposed or voted on. Now you have the Common Core pieces. Again, there are several other bills that were proposed that have to do, that are law now, that have to do with funding of training of teachers in Common Core. For example, that bill was passed last year. So there are other little pieces that are already in law too, having to do with Common Core. So again, my advice is simply to don't take anyone's word for anything, mine or anyone else's. Do your own homework, research the law and any bills that are being proposed, and then take reasoned and appropriate action. Most importantly, go interview your state senator, your state representative, and any candidates running in your district for what is their opinion on parental rights on all of these issues. And depending on what they tell you, either work for them or against them, because that is the most effective way. Right now, before the November elections, I suggest you do that immediately so that you know who to vote for come November. Okay? That's all I have. I'll be happy to answer any questions now or later or whatever everybody prefers. But thank you very much for coming.